Good morning, Kenyans. A tree cannot bend for you to climb. You must start climbing it from somewhere. The current state of Kenya as a country is this. We have an emasculated legislature which has now been declared illegitimate. We have an overbearing executive which does not want to act within the confine of the Constitution or any law. We have a judiciary which, despite determination to act independently and accountable, is forever being undermined and weakened by those other two arms of government. There is need for the people of Kenya to exercise their sovereign power as given to them under Article 1 of the Constitution. It is therefore towards that cause that like-minded Kenyan leaders have come together to provide direction on how best to deal with this issue. With me are these leaders who today and the day after we shall spearhead the course towards ensuring that the people of Kenya assert their sovereign power. The four of us are going to speak. I will allow the other speakers to speak, whereafter I will speak in conclusion. Karibuni, asante.
Good morning. In September 2017, the WeAre52pc Feminist Collective were the first parties to petition for the dissolution of Parliament. Our demands for the inclusion and representation of women, and indeed all Kenyan people, is a reflection of our belief in the Constitution as a tool for better lives kwa Kenya wote. The High Court case the government has brought amounts to an attempt to subvert constitutional order to ensure that politicians are not held accountable for the failure to do their jobs and that they cannot be limited by any law. Parliament since 2017 has been an unconstitutional and unlawful body operating outside of the constitutional order. It does not deserve judicial audience or legal protection. In effect, it is an attempted coup. It is alarming to us that this very tool has been used for political patronage and unlimited power under the current administration. As the majority of people to whom all sovereign power belongs, we reject this illegal attempt by government to establish themselves above the law. This is a call to action. Parliament must be dissolved. The court case is merely to permit the connivance of an illegal cabinet and an illegal parliament to continue the politics of patronage and misuse of public resources. We refuse to be silenced at these illegalities. We will continue to demand the dissolution of parliament and the resignation of the cabinet. Despite the serious socio-economic implications of the pandemic on all Kenyans, we continue to see a politics that is responsive only to the political elite, political projects that focus on mega infrastructures, while Kenyans are losing lives and livelihoods, while the majority of us lack basic needs from access to clean water, medical facilities, and meaningful opportunities to progress in life. The breakdown in the legal and governance framework has also facilitated theft of public funds in a way that has left many Kenyans impoverished. In a worldwide pandemic, our doctors and nurses are disregarded with poor or no PPEs, under and unpaid. Who will take care of us while the elite have access to private top-notch medical facilities that pay fully funded by you and me? Yesterday, the Ministry of Education directed the reopening of schools. They don't care that some families have moved children up country to minimize living expenses and ensure their children's safety. They don't care that many families have reduced income and most Kenyans are supporting more family members that we did before. That our growing children of Kenya will need new uniforms, that free public school education in Kenya is in fact not entirely free. Where is this money coming from? Where is the time to plan for this? Wapi sauti ya wazazi? All these political projects aren't just out of sync with our needs and aspirations as Kenyans, they are provided at rates that will shock the local loan sharks. Debt is out of control because the political class is out of control. Wanatunyanyasa. This regime is united in its commitment to the violation of the Constitution and its oppression and disregard ya Kenya. This illegal parliament and unconstitutional cabinet by this administration must resign because an unconstitutional parliament approved the nominations of an unconstitutional cabinet. They are all complicit. This arrogance and defiant refusal to engage Kenyans kwa heshima na utu is what comes when politicians believe they are above the law. Tunakataa. We refuse to accept this leadership of contempt. Kenyans must collectively refuse to accept this. Thank you.
Kenyans, good morning.
Good morning.
The Constitution of Kenya, 2010, Article 3, Sub 1, states that every person has an obligation to respect, uphold, and defend this Constitution. We stand here today as the United Green Movement in partnership with the Law Society of Kenya and the WeAre52%, together with other concerned Kenyans, to make a special appeal that time for us to stand by our Constitution is now. We the people hold the sovereign power, and we must exercise it. We stand here today to ask for the dissolution of Parliament for 4 reasons. Number 1, the Chief Justice, about 3 weeks ago, advised our President to dissolve Parliament since Parliament has failed in its obligation and legislative duty over the last 5 years to enact a law that is anticipated pursuant to Article 27 of the Constitution of Kenya. Article 27 of the Constitution deals with equality and freedom from discrimination. Through the 2/3 gender rule, we say that women emancipation is not an act of charity. It is a fundamental question of equality. Women hold up the other half of this country. Emancipation, like freedom, is not guaranteed, it is conquered. We must then put forward these constitutional demands, since whatever affects one directly affects all indirectly. We must then mobilize to win against inequality, and that's why Parliament must be dissolved. 2, we have witnessed a huge appetite for government borrowing. Kenya is reeling under the weight of huge public debt. This debt has accumulated and has been accumulated by the executive, contrary to the provisions of Article 220, which requires proposals regarding borrowing and other forms of public liability that will increase public debt must be contained in the national budget. None of this parliamentary oversight and scrutiny has happened over the years. This has left an unchecked executive overburdened with debts that we do not need. In essence, the failure of parliamentary oversight has constantly fueled inequality and the attendant discrimination, where a narrow elite borrows money on our behalf, monies that we do not need, for their own enrichment, leaving the rest of us in poverty and debt-laden. We must stop this by dissolving Parliament now. 3, we have seen this Parliament fail in its oversight role with cases of corruption. Most recently, corruption in the theft of COVID-19 funds. The Senate sat to listen to the evidence on this theft, just to end up with no single senator voting to adopt the report. We have seen the case of leased medical equipment to the counties. Parliament has investigated, nothing and no conclusion has come, with no one being held accountable. This Parliament mocks us, and we must stand as Kenyans to say no. And as we say no, we must demand that, Parliament gets dissolved now. Fourth, and lastly, on representation. The school calendar changes every time we wake up. Parents cannot even plan. We don't know whether schools will open tomorrow, whether they'll open on Christmas Day, whether they'll open in February next year. Parliament has refused to hold the Cabinet Secretary for Education to account. They no longer represent us as Kenyans. There's 18 million of our children who have not attended school in almost a year. And the Parliament that is supposed to stand up and represent us has kept quiet. We therefore again stand here to say this Parliament must be dissolved. The President of Kenya must dissolve Parliament through the advisory that the Chief Justice gave a few weeks ago. We are aware that he has given the reason that he is waiting for the outcome of a High Court case filed by a few petitioners on an interpretation of this advisory given by the Chief Justice. It is our considered view that his answer lies in Article 2, Sub 3 of the Constitution, which says the validity or the legality of this Constitution is not subject to challenge by or before any court or other state organ. So if the President does not dissolve Parliament, we will lead Kenyans to issue a vacation notice to our parliamentarians. We shall move to ensure that this Parliament that is illegitimate does not conduct any business on behalf of us Kenyans. They have failed in their legislative role by failing to enact the 2/3 gender law as found by the Chief Justice in line with Article 261, subsection 7. They have failed in their oversight role to contain public debt. They have failed to tame runaway corruption. And they have also failed in their representative role by ensuring that our children stay at home without any school or otherwise any programs during these very strange times. It is now our considered view, therefore, fellow Kenyans, that in furtherance to Article 1 of the Constitution of Kenya 2010, we must push for the dissolution of Parliament. The President's power to dissolve Parliament is delegated power, and our reading of the Constitution tells us that we can also exercise this power directly as the Mwananchi. Let us join hands, fellow Kenyans, in respecting, upholding, and defending our Constitution. This obligation starts with the demand we make today to dissolve Parliament. We all need to unite as citizens of this country to ensure that plenty is found within our borders, that every Kenyan is equal before the law, and that we have equal right to protection and distribution of resources. We thank you. May God bless us all. May God bless Kenya. And now I'd like to invite my friend, the President of the Law Society of Kenya, to come and conclude this press briefing. Bwana President.
Okay. Thank you, Jonathan. The call is this: Parliament must be dissolved or occupied effective the 12th of October 2020. Parliament must be dissolved or occupied effective the 12th of October 2020. Why do we make this call? We make this call not only because the Chief Justice has advised the President of the Republic of Kenya to dissolve Parliament. There are many other reasons, as have been enumerated by our colleagues here. As we speak right now, the Cabinet itself is unlawfully constituted. As we speak right now, the judiciary is not facilitated as required by the Constitution. It cannot be explained why the Treasury will refuse to disburse a mere 500 million to the judiciary to enable the effective and optimum delivery through the e-filing and the e-court. Yet, the executive can, within a day, approve 2 billion shillings and further amounts of money towards causes that do not add value to the people of Kenya. What does this demonstrate? It demonstrates a failure of leadership. And when the Chief Justice advises the President of the Republic of Kenya to dissolve Parliament, the Chief Justice does not act on his own. He acts on behalf of the people of Kenya. And similarly, when the President of the Republic of Kenya is required to dissolve Parliament, he does not do that as a fiat. He does that as a delegate of the people of Kenya. It follows, therefore, that if the President fails to act in accordance with the will of the people of Kenya, he has violated the Constitution. And this will not be the first violation of the Constitution by His Excellency President Uhuru Kenyatta. It is a culmination of many acts and omissions of violations of the Constitution. I can only mention one: the refusal to swear in 41 judges, which has persisted for almost a year now. And what does the President of the Republic of Kenya tell you? He goes to a hotel in Paris before a French journalist in the midst of his quest to go and burden you with more debts through loans, that the matter is now pending before court. I will not act until it is otherwise determined by the court. Let me tell you two instances where a similar statement has been made before. This statement was made in 2008 when the election of President Uhuru Kenyatta was contested. What did they say? Go to court and have it determined. Because they were certain they had control of the courts. They made the same statement in August 2017. Go to court and have the matter determined. Why? Because they knew they will either control, coerce, cajole, or compromise the judicial process. And when they did not succeed in doing this in 2017, they promised to revisit and fix the judiciary. It is on this backdrop, therefore, Kenyans, that you must appreciate the statement from the President of the Republic of Kenya that let the matter be determined by the court. Where does he get the assurance that the matter will be determined in his favor? This is the assurance. They have revisited and fixed the judiciary. It should concern you that several state organs, state agencies, are suing each other before one state organ. Does it really make sense that the Attorney General will originate a case against the Chief Justice, the Speakers of the Senate and the National Assembly, and on the other side, the Speakers of the National Assembly and the Senate will originate another claim against the Attorney General and the Chief Justice? And where are the 6 petitioners on whose behalf, as representatives of the people of Kenya, the Chief Justice acted? They are nowhere. The intention is obvious, to compromise this litigation. And it must be understood that the President himself gave a directive in the month of July that there shall be no suits between state organs or state agencies. What has changed? The Constitution was not intended to be challenged before a court of law. None whatsoever. This morning, Justice Weldon Korir has delivered a ruling in respect of the election of the member of National Assembly for Gatundu North. And he has said a constitutional provision cannot be challenged before a court of law. What is it that these state organs and agencies are brought before a court of law? They want to determine what is public interest. They want to determine what is the meaning of the word shall. Really? The meaning of the word shall to be determined by people who claim to be the advisors of the government of the Republic of Kenya? Logic has been turned over its head. We respect the authority of the judiciary, but we cannot be put in a position as the people of Kenya where those who hold the highest responsibility of violating the Constitution and disobeying court orders now want to take the people of Kenya to court and burden them with court orders that they have obtained through coercion, connivance, and compromise of the judiciary. This cannot happen to the people of Kenya. It is for this reason, therefore, that we want to hold all the three arms of government accountable, commencing with Parliament. Parliament ought to be dissolved by 12th, failing which we will occupy it with a vacation notice issued to the parliamentarians. And you, the people of Kenya, must play your role. You must call out your elected members of National Assembly and the Senate. Tell them they are in office illegally. They have no business to transact. We want you, the people of Kenya, to talk to our partners, local and international, and tell them the Parliament of the Republic of Kenya cannot offer oversight in respect of the loans that President Uhuru Kenyatta is taking day after day. And I want to tell the government of France, the people of Kenya will not be held liable on this loan that they have given President Uhuru Kenyatta. They may as well recover that loan from President Uhuru Kenyatta personally, now or when he leaves office. It is as simple as that. Let's go now to the executive. The executive must act in the best interest of the people of Kenya. We have seen the suppression of the right and freedom of speech. We have seen the curtailment of the right and freedom to associate, the right to picket, the right to strike. Why? Because the executive does not want the people of Kenya to benefit optimally from the rights due to them under the Bill of Rights. Why can you explain at this particular point in time why a leader requires a permit to speak to his people? Why a leader requires a permit to hold a public rally? And these fetters are being put, yet these rights are given under the Constitution. So the executive must be held to account. What about the judiciary? We stand for the independence of the judiciary. And we want all the people of Kenya to stand with Chief Justice David Maraga and all his judges to ensure that they are able to give determinations on matters amongst the people of Kenya and between the people of Kenya and the state without fear. Because as we speak right now, I know as a matter of fact that the judges are under fear on how to deal with the cases in respect of the advisory of the Chief Justice. May I encourage you, judges, do the right thing. The people of Kenya will be behind you, as were the people of Malawi when the judiciary did the correct thing. Way forward, on the 12th of October 2020 at 2:30, these friends assembled here will visit the two clerks of the National Assembly and the Senate and the speakers, if they will be there, to issue them with a notice to vacate. Over and above that, as we disperse from here, we want to travel all over the country and speak to the people on the need to exercise their sovereign power. On my part, I'll commence my tour with Western Kenya tomorrow morning. I'll be in Busia at 10 a.m. I encourage you to come out in large numbers. Advocates, professionals, their leaders, well-meaning Kenyans. At 12 noon, I will be in Bungoma. At 3 p.m., I'll be in Kakamega. At 5 p.m., I will be in Vihiga. What message are we putting across? Dissolve or occupy Parliament. This has to be done here and now. Not tomorrow, not the day after. Those who claim to lead must yield to the demands of those who hold sovereign power, the people of Kenya. We will take a few questions. You will field your question to whoever you want to answer it. Thank you. Then you'll pose your question.
The call by the Minister for Education.
I will defer that question to Honorable Jonathan. Jonathan, you will answer that question. Next. I will take that one. Next one. Okay. I'll also take that one. Okay. Marilyn will take that one. Next. Or we answer those first? Okay. Fine. We'll start with you, Marilyn.
So if I heard you correctly, the question is whether dissolution of parliament will cause a constitutional crisis. And I think you've heard us say that the constitution itself does not envisage a challenge to its legality or its validity. A constitutional crisis will only exist if we continue to have institutions of government purporting to act under the constitution but not bound by it. So a constitutional crisis will exist if we do not dissolve parliament, because if we do not dissolve parliament, then we are acting outside of the Constitution of Kenya, and we are essentially in no man's land. So if we do not dissolve parliament, we have a constitutional crisis. And please remember, this parliament has been illegal since 2017. So the dissolution is related to the failure to enact legislation. However, the illegality of parliament predates the dissolution order. It goes back to 2017 because it is illegally composed. So the constitutional crisis is in the hands of the president. Should he fail to dissolve parliament, then we do have a constitutional crisis.
On schools reopening, an announcement has been made that our children should go back to school. What concerns us is there's no plan. They are called to school today. The teachers have been in school for 2 weeks. The president said schools can't open without a plan. Now we hear schools are opening without a plan. Are there plans in place for teachers to be tested for COVID-19? Are there plans in place for our children to be tested for COVID-19? What is the plan to ensure the health and safety of all those who work in schools? Have the parents been consulted? Can they afford to take their children to school? Have they planned adequately for this burden? Somebody just can't wake up in the morning and off the cuff decide that he's going to do whatever he wants to do. That's not how a country or an institution should operate. So we have to ensure that a solution be found for our children to go back to school that makes sense. And it is the responsibility of the government, because it has been elected by the people, to work for the people. They should put together all the resources at their disposal to ensure that they find this solution in consultation with all the stakeholders in the education sector. So our position is you just can't have knee-jerk reactions to the future, the health and the safety of our students, of our teachers, of the workers in all the schools, and anybody else who is a stakeholder in our educational system.
I will take Khaemba, is it Khaemba? Or Mebro? I'll take Khaemba's question, then if there is any other questions, you'll ask them. We'll allocate them amongst ourselves. Your question was, this government has distinguished itself in the disobedience of court orders and violence, and whether we will be meted with violence when we visit the two clerks of the Senate and the National Assembly on the 12th of October 2020 at 2:30. I believe that was your question. Well, you have put it in ways that are much better than I will have put the issue. We are not asking the people of Kenya to revolt. This is not a revolution. This is an assertion. What are the people of Kenya asserting? They are asserting their sovereign power as given by the Constitution. And to that end, therefore, the enterprise we propose to take effective today, and in particular on the 12th of October, is a legal enterprise. It cannot be subject to criminal sanction. We will proceed there in a civil formation within permissible numbers and in an orderly way to seek audience with those two state officers. And we hereby notify the Inspector General of the National Police, my very good friend Hilary Mutyambai, not to waste public resources by deploying their tanks, by deploying their armed policemen, because we are all law-abiding people. We are going for a civil mission. We do not therefore expect that there will be violence. On our part, we want to encourage all Kenyans who want to participate in the assertion of their sovereign power to exercise it within the confine of the law. We are living in a modern world where revolutions cannot be the order of the day, where we do not take arms, where we do not resort to violence. The Constitution has given us a very elaborate way of exercising power through delegates or directly where delegates have failed. And that is what we ask Kenyans to do, act within the confine of the law. Mr. Honorable Neto will take the subsequent questions. Ongeza sauti tafadhali.
nitajaribu kuongea Kizungu kwanza, alafu baadaye nitajaribu kwa Kiswahili. But let me just say a couple of things first. My colleague Jonathan said we are here together as the United Green Movement Party. We are 52% and the Law Society of Kenya. First is to acknowledge the fact that we are law-abiding citizens. The Law Society of Kenya is a crucible of law in Kenya, so they should and ought to be law-abiding citizens. The United Green Movement Party is a political party that believes in non-violence. It's part of our political philosophy. Now, to the question that you asked whether there's going to be a constitutional crisis, we invite you to listen to lawyers from the Law Society of Kenya and those ones that Mr. President has not registered from being members of the Law Society of Kenya. The Constitution of Kenya at Article 261(8) presupposes that upon the dissolution of Parliament, there will be an election, and that election is to a 5-year term, and the term of that particular election is therein in the Constitution anticipated. People say that there's going to be a constitutional crisis because they refer to the aspirations of Article 102 that the election of Parliament should be also within the meaning of the election of the presidency. That is not true, because if you look at the Committee of Experts report on the Constitution, they had anticipated a Parliament that would have gone rogue, like this particular 12th Parliament. And that is why it was put, the person who is on the offensive is the House of Parliament. It will be dissolved, and the people of Kenya shall elect a new Parliament, and the term of that particular Parliament is therein in the Constitution contained. So there's no vacancy, there's no crisis. That's the first question. As to the second question with regard to whether we expect to have violence on the 12th, and Mr. President has of course responded to it. But let me say this. As the United Green Movement Party, alongside us, the Law Society of Kenya, did issue a notice to vacate. Now, we are going to Parliament on the 12th in a civil manner to tell the tenant, who is members of Parliament, represented by the clerks and also the speakers of the National Assembly and the Senate, that they are illegally occupying our house. And like we said, we are lawyers and we are law-abiding citizens. We are giving them a framework within which we will have a conversation with them on 12th, very civil. We are not asking Kenyans to just come to the streets as yet. No, we will get there. Because as Mr. President has said, sovereignty belongs to the people. We will do every practical step as is required by law. We have issued a notice to vacate. We will give them the notice now that it's time to leave. We'll give them a couple of days. And we know for a fact, and you've said it, they are up to disobeying court orders from time and time again. We shall help Kenyans gain back the rule of law. Sasa kwa kuambia kwa kifupi ni ya kwamba tunasema ya kwamba sisi ni Wanakenya ambao tunaheshimu sheria. Na vile vile sisi ni wanasheria. Hatutaki kufanya ya kwamba kutakuwa na malumbano yoyote na wanasheria au askari polisi. Tunasema ya kwamba katiba lazima itimizwe, na tunasema ya kwamba kipengele cha kwanza cha katiba inatuambia ya kwamba Wakenya ndio wako na uhuru na jinsi ambavyo wanataka ya kwamba katiba itekelezwe. Tunasema ya kwamba wasipotekeleza katiba kwa vile tunataka, hakimu mkuu tayari amewaambia ni vizuri wajue ya kwamba kama wataki kuitimiza tutatumia kipengele cha 37 ambayo inatuambia ya kwamba peacefully and unharmed Kenyans can walk and get to make demands that parliamentarians vacate. Fellow Kenyans, that is the call we're asking you for. I do not want to take so much time. Mr. President only asking me to come and respond to those questions. The notice to vacate on the 12th will then be followed by sets of activities, like the President has said, until this particular Parliament goes home. And when it goes home, fellow Kenyans, we must elect responsible leaders to the House of Parliament, because that is what the aspiration of our Constitution. Thank you very much, Mr. President.
Well, as I stated before, the issue insofar as the advisory by the Chief Justice is concerned has the protection of the Constitution. The Chief Justice's decision cannot be challenged in a court of law. And whoever has gone to a court of law on this decision has only two intentions. One, to delay the eventuality of the obvious dissolution of Parliament. And two, they could only be going to court when assured of an outcome. Look, it is not the first time that a judge of the High Court of Kenya, the Court of Appeal, or the Supreme Court makes a decision that is inconsistent with the Constitution. As lawyers, we know these incidences abound. And it's for that reason that we have stood here to stand in solidarity with the judiciary. We are not countermanding the legal process. We are pleading with the judiciary to make the correct decision. And we know what the correct decision is. You cannot tell me the Chief Justice can make a decision which a High Court judge will find to be inappropriate. No, it can't be like that. We therefore ask the judges to take into account a very fundamental fact, in fact two. One, that the 6 petitioners who asked the Chief Justice to dissolve Parliament have not been taken to court. So what is before court? And 2, arms of government cannot sue each other. It is simple as that. It is worse than incest. We cannot condone it.
I really would like to emphasize this because it's really important that the media understand. What is in court is the Chief Justice's advisory opinion. What is not in court, and it is not controverted, is that the 12th Parliament is unconstitutional. And per Article 3(2), it is unlawful. Okay? So please separate those two issues because they are distinct. And when we are speaking about an unconstitutional parliament, we are speaking about a matter that has existed since 2017, and it is uncontested and uncontroverted. Okay? And we are not asserting that we are in any way countermanding the court process, as Mr. President has said very clearly. But it is also important that you report to Kenyans the facts as they exist, which is that an unconstitutional body is seeking protection of the Constitution. Where does that happen? What framework allows an unconstitutional body to seek protection of the same Constitution that it is violating? And that's a distinction that I think is really important that Kenyans understand. Thank you. I think we're done, right?
Yeah.
One last second.
Thank you so much. Please give this issue the coverage it requires. We rely upon the media to inform Kenyans, just as we rely upon leaders to provide guidance and upon lawyers to give legal direction. We have given you all this. Thank you so much. God bless you.